first case, please.
Angela K. Plese v. Ronald Boston et al.
We'll hear from the appellate when you're ready.
Thank you, Your Honor. I would like to begin with how the allocation of time we expect to work. I'd like to take for my principal argument 9.5 minutes, reserve 4 minutes for rebuttal, and I'm going to cede 1.5 minutes to the state of Tennessee.
Okay.
And I believe that by agreement, the appellee will also cede 1.5 minutes. So the order would be me, the state of Tennessee, Mr. Mitchell, and then my rebuttal.
Okay. I think I understand. I'll just say next.
That should work, Your Honor.
Yeah.
Thank you.
Okay. So right now you've got 9.5 minutes. Okay.
Thank you, Your Honor.
Go ahead.
This case is about policing the internet and whether this court and other courts in the state of Tennessee want to do that. I've read multiple appellate opinions where one party argues that if the court sides against them, then there will be a harm and an opening of the floodgates of litigation based on that issue. I'm not going to sit here and say that the floodgates would open, but upholding a $100,000 defamation verdict for a substantially true Facebook statement and another that is absolutely true, but did not receive a lawyer's blessing, would open a barn door, and that barn door would be full of horses, and it's just a question of how many horses figure out they can get free. And by horses, I mean lawyers and plaintiffs, and by get free, I mean can they get money for pursuing an action like this. This is not a situation, and Your Honor and Your Honors, it is important, I think, to note that context is important, and this is not a case where the consequences were obvious or are obvious. This is not a situation where completely false and malicious statements were made, for example, accusing someone of a sexual offense or domestic violence that were made on the internet, and those who saw those statements started threatening the target, whether the target lost their job, or that there were some tangible consequence from internet statements other than the statements themselves. A good example, in fact, of what I'm talking about is a case that's relied upon by the appellees in terms of their argument regarding harm, and that is Moore v. Bailey, Your Honors. And in Moore v. Bailey, there is a 10-year running dispute, and the defendant in that case accuses the plaintiff of misappropriating public funds, drug use, etc. And in terms of a real consequence, the plaintiff in that case he was investigated in his job. His life was immediately affected, and his reputation was tangibly harmed by the statements that were made against him.
In this case, though, which I think is interesting, and sort of to counter your argument about it opening the floodgates, I think a lot of times in these defamation cases, what narrows them down and makes them challenging for plaintiffs to pursue is that lack of harm. It's hard to show sometimes in defamation cases that you've got some sort of tangible damage to reputation or harm, but this plaintiff in this case was kind of in a unique situation because she did have pretty concrete medical evidence to show that she suffered a pretty significant mental injury as a result of this.
There is no doubt, Your Honor, that Mrs. Austin suffered as a result of these comments. And I think that the trial court was very empathetic toward Mrs. Austin, and I think understandably so. However, there are several issues, I think, that to break into the argument regarding harm. I think there are several issues here. The first is it is confusing in terms of, was her harm actually caused by a defamatory or a statement that was made in false light? And I think that the medical proof that has been, I think, thoroughly combed through in the briefs does not reference really at all a gun. And that's really the one statement, the one thing that is involved in this that is not exactly true. It is based on Ms. Plese's misinterpretation of Texas's penal code
That's the
statute.
only statement the trial court found to be untrue.
Yes, Your Honor.
Okay.
Yes, there were four, and for context, there were four statements that were made, and the trial court found that two of them cast Ms. Plese in a false light, and that this statement, she was arrested for deadly conduct with use of a gun. And that is the one statement that is not true. The other statement, Linda Austin pleaded guilty to the charges of deadly conduct in Texas. That is 100% true, and frankly, its implications are true. So we would contest that just as an initial matter, that is not a false light claim, or that is not appropriately false light. The issue with the gun is it's not even that the deadly conduct, because that's true. That part of it is true. It is with use of a gun. And so that is with a use of a gun, and we are standing here in East Tennessee, and that is apparently the defamation issue. However, to go back to Judge Davis's point about the harm, and to wrap this in generally, there are four statements that were made, and it is somewhat confusing in this case which or all of the statements caused that harm. I would submit, Your Honor, that it is more that Mrs. Austin was re-triggered from a prior event by generally bringing up the true part of that, the true part of what Ms. Plese said, which is the deadly conduct and the underlying DUI offense. And it is the disconnect between one and the other that is truly a problem here. And I think the medical proof, although substantial, and although it does show that Mrs. Austin suffered harm, does not tie directly to gun. And I think that's exceptionally important.
I mean, are you arguing that the evidence is preponderant? Because the trial court found and awarded damages, $5,100, I think, for the medical. Mm-hmm. Are you arguing that the evidence preponderates against that finding?
Yes, Your Honor, I am.
Okay, so that's what you're arguing, is preponderance of the evidence standard, that the evidence.
Yes, Your Honor. It does
Okay.
not. It does not. And I argue that we argue that in part because of the record, and there are several different factors with respect to that, and I'm talking about more the causation. I don't believe that it preponderates. That the preponderance of the evidence shows that the use of a gun statement was the cause of the harm. And secondly, Your Honor, with respect to the harm, we submit.
On appeal, it's not which way the evidence, it has to be the evidence preponderates against the trial court's finding.
Yes, I misspoke.
Tie goes to the runner,
yeah.
like in baseball.
I understand the evidence preponderates against the trial court's finding in that regard. And in addition to that, I think as a prerequisite, and it's our position that as a prerequisite, reputational harm is necessary. It is not sufficient to simply suffer harm because a statement was made to you. There has to be some reputational harm, some reputational injury that occurs as a result of this. And I don't believe, and in this case, there is no reputational harm that occurred to Mrs. Austin. And in terms of context, and in terms of going back to the internet, we are talking about what other people view and how other people view the internet. And we're also talking about the proof at trial in this case. The argument is that 1,000 people could have read it. Ms. Plese had 1,000 followers. There were 3 that commented and none that showed up at trial. Mrs. Austin argues that her fears of reputational harm are enough to support the damages in this case. We submit that it's not, that the majority of holdings, the vast majority of holdings, except for one really cited by the appellant or appellee, stress that reputational harm is critical in proving damages in a defamation case. And with respect to and I'm since I'm on it, I'll continue. But to the extent that the appellee raises Miller v. Piggly Wiggly, that case was decided over 30, or the incident in that case occurred over 30 years ago when the internet was less than 5 years old. I think that the context and the change in times has to be viewed in this case, especially when reputational harm and I think concrete evidence of reputational harm has been found in so many different cases to be critical.
Thank you. As I said, next, we do appreciate you all having worked out the order, because I was sitting here and trying to draw up who was going when and where. For the appellee.
May it please the court, Grant Mitchell for the appellees, Ron and Linda Austin, the plaintiffs in this case below. Lots of potential issues to talk on and limited time, but I wanted to begin by picking straight up on the policing the internet argument that my opposing counsel began with. Describe this in the Austin's brief as the parade of horribles that the Plese brief opened with if this defamation and false light judgment is affirmed. I don't believe that carries weight because this plaintiff was in a unique situation, as Judge Davis noted. There are also other unique factors to this case that make it different from many other internet cases. The stipulations and understandings read at the beginning of trial that narrowed the issues that were in dispute, what proof was needed and what proof was not, made it clear that this was not a case on an issue of public concern. There was never any anti-SLAPP or TPPA dismissal petition filed in this case, as there often are in defamation and other cases like this. And so in addition to other aspects that would change the elements of the claim or add other threshold barriers or protections for defendants, in many internet cases and internet situations, those for different reasons just never came up in this case. So I don't believe that this is the this case has the sweeping potential that my opposing counsel argues. The importance of Your Honor was asking about the preponderance of the evidence and the trial court's findings below, and the standard was properly read. But I believe that in this case, that standard and the importance that this court gives to credibility determinations, especially those that are expressly stated by the trial court, is very important. A moment ago, he was talking about what he sees as the causation argument, that he says it does preponderate against. It's not about the gun, and he called that substantially true. I believe and submit to the court that that goes firmly against the trial court's findings, including as to the credibility of these witnesses about what occurred. And the trial court found Dr. Rogel, the treating physician, to be a credible witness. The trial court's final order is very detailed and makes numerous credibility determinations explicit. It's in the technical record beginning at 163, and I would encourage the court to that order. I probably would have been well served to have quoted more of it in the briefing, but I believe the trial court did a very good job and detailed, thorough order in this one. I'm jumping around a bit, and I apologize, but one other overarching point.
Let me ask you a question.
Yes, sir.
Yeah. What evidence was presented as to reputational damages, the injury there? What evidence did the trial court have before it?
The reputational injury in terms of publication was proven through judicial notice and the Facebook statistics that have been referenced. But in terms of the damage
to your client's reputation.
Correct. It was through her own testimony regarding fears which have been expressed and discussed. But that was further supported through circumstantial evidence from her husband about how his wife reacted following this event. I'm sorry.
I didn't mean, I'm sorry to interrupt, but isn't that more towards her emotional damages? Because the trial court awarded the sum for emotional damages and a sum for reputational damages.
If any aspect of fear puts it in the emotional bucket, then maybe, but I believe not, Your Honor.
How would they go to, how would that show any damage to her reputation?
Because the trial court heard, for instance, before the posting at issue, the plaintiff was in the insurance industry as an insurance agent or sales person, and that afterwards she withdrew from that, not feeling able to meet with clients, and so that there was stress in the briefing about reputational injury really needs to be economic. There was an older case that was cited for that, but that is even an example that's economic right there. It's tied to her job. The other, in terms of just whether that reaction by plaintiff withdrawing from community events, the trial court heard not only testimony, but saw photographic exhibits submitted of events before the posting and events, and then heard about the medical proof afterwards. But she withdrew from a KEMA, charitable fundraising event that she had been very active in before, because of being unable to go out into the community due to the harm that had been done, and further that was continuing to be done, because there was before a lawsuit was filed 4 days after the posting, there was a cease and desist or retraction letter sent, Exhibit A, to the complaint, and it took approximately a year before a retraction offer was extended, and so that harm was continuing in this case as well. And so I think the reputational injury was proven through Mrs. Austin's own testimony, her husband's testimony. It was further circumstantially supported by her doctor's testimony about the reaction that this causes in withdrawing from the community. A fight or flight response were his words, and that's what this loss of control that she suffered from the publication caused. And that is the interest that this tort protects. It's that control over one's reputation in the community. Another overarching point that the court has heard about in briefing is that the parties all strove to have an efficient trial here. Jury trial was waived. It was a bench trial. We had limited witnesses, and we announced those stipulations at the beginning of trial and limited the theories and the proof. But what that also meant was that the defendant was not advancing a bunch of different theories. The defendant said it was not disputed that she posted it. A lot of the elements were proven. She just said at the beginning that she was going to have an explanation or an excuse. When it came time for the defendant in testimony, after the trial court had already read and received some of the defendant's designated deposition testimony on certain points, the defendant took the stand live at trial. She didn't provide a credible explanation. The trial court found that her explanation that she didn't, for the first time at trial, inconsistent with that deposition testimony, that she didn't realize she was in making that post. This is a frequent Facebook user, the trial court heard, but in making this post, she didn't realize that she was doing it publicly. She thought she was just having a chat with friends. That's the defense, the only real defense that the trial court heard in terms of justifying this action that the trial court found was not only done with reckless disregard for the truth. The paperwork that the defendant obtained that would have supported a misdemeanor, not the one she posted about, and she posted deadly conduct with a gun, which under Texas law is a felony. There's a significant difference with that. Under the old law, wrongfully being accused of a criminal act like that would likely qualify for, per se damages. And so that isn't the law any longer, but that really supports that this was a statement capable of carrying a defamatory meaning. And then the trial court heard that there was going to be an explanation for why this happened, announced at the beginning of trial, and that explanation, at least one that the trial court found to be credible, never came. And so that further supports that the plaintiff's theory as to why this occurred. There was a history of bad blood there. This was something that the defendant found and used, yes, on the internet, with all due respect to the disagreement on whether this is a landmark internet case. This did occur on the internet, but this was just the next thing that she used to get at the plaintiff, and the trial court found that that was not only with reckless disregard for the truth, but also that that was malicious, and both of those findings support the punitive damages award, which it was a modest punitive damages award. It was announced earlier that this is a $100,000 case. I think the briefing has shown that through a typographical error, it's 95,100. It's a slightly lower amount, but the punitive award of that is only $25,000. And so in a case where the parties all strove to be efficient, no party, no motion from the defendant, no pleading and an answer, no one asked at any point for bifurcation, the trial court made separate findings in its order, doing all that would be necessary to support the punitive judgment had the proceeding been bifurcated. And for the first time on appeal, Plese's opening principal brief argued that in one of the issues that bifurcation, failing to bifurcate below, warranted a new trial. The trial court did solicit and receive post-trial briefing, and that was another opportunity where bifurcation could have been requested but was not. So we would ask on that, I could call it the final issue, whichever order the court addresses it, that on that punitive damages issue, that the challenge be found waived. If it is not waived, there's an attorney from the state of Tennessee here today to defend the constitutionality of the statute, because we pointed out in our brief that if that statute is found to be mandatory as to a bench trial where bifurcation's never requested, that violates separation of powers. The procedure for punitive damages proceedings was set forth in Hodges, so that came from the judiciary. The language in Hodges said on motion, the proceeding shall be bifurcated. And that was the law for years. The General Assembly in 2011 changed that law, did away with the on motion language. And the law has subsequently been interpreted by the Western section to be mandatory in a bench trial, regardless of whether a motion is filed. We believe that this case and the way the briefing with the constitutionality issue is raised as well just supports that trial courts need to have the discretion to proceed without bifurcation when it's not requested. But if it's found to be mandatory, the test for separation of powers challenges was set forth by the Supreme Court recently in Wilford, and it's within Lexis Head Note 13 for that opinion. I believe it's part of the holding that in discussing the several different tests for statutes, in talking about the statutes that aren't exclusively substantive or procedural, believe Hodges said that this is the procedure, but I recognize that there are substantive and procedural components to our punitive damage statute. It says where the court has promulgated the rule that relates to practice and procedure, and a statute provides a contrary practice or procedure, the statute is unconstitutional to the extent of the conflict. It also provides, this is coming from Wilford for the test, that where a statute has some substantive aspects, but the procedural requirements of the statute conflict with or interfere with the procedural mechanics of the court system, those requirements are unconstitutional. I believe this violates separation of powers on both accounts. The rule from Hodges, not a rule of civil procedure, but it was a rule from the court system, and this is in conflict, direct conflict with that. It's also directly in conflict with the discretion that trial courts need over decisions whether to consolidate trials, handling the procedures before them. If a court receives an arbitration award where punitive damages have been awarded and is asked to confirm that award, arbitration shows the parties have tried to be efficient. No party asked for bifurcation. Is that court really required by this statute to nonetheless bifurcate the confirmation of that arbitration award because there are punitive damages? I think there are numerous reasons why that discretion for trial courts needs to be retained. And so I have sped through and probably passed some of the issues, and I see my time is quickly ticking. If there are no other questions, I'd like to just speak on the other issue that was raised in terms of whether the trial court erred in amending to conform to the evidence to award Mr. Austin, who was a plaintiff from the beginning, consortium damages, also a modest amount. The primary purpose or primary point I want to make there is that is, I think all parties agree, an abuse of discretion standard that should be applied. And in looking at whether the trial court abused its discretion in amending to conform to that, I think the court should find not. There was notice in the interrogatories and deposition testimony to show that was an issue. So I'm out of time. Thank you.
Thank you. We'll hear from the state.
Thank you, Your Honor. My name is Heather Ross. I'm with the Attorney General's office, and I'm here.
Would you pull the microphone down just a little bit? Thank you.
I'm from the Attorney General's office, Heather Ross, and I'm here to defend the constitutionality of the bifurcation statute. That's the statute that requires bifurcation when punitive damages are at issue. But as an initial matter, the state would submit that the doctrine of constitutional avoidance really would dictate that this constitutional issue need not even be addressed in this particular case. The briefs themselves indicate that there are 5 issues, many with subparts, and that the constitutional question is implicated in only one subpart. In the reply brief, it's not addressed at all. In the plaintiff's brief, I believe the plaintiffs give 3.5 pages to the argument in a 59-page brief, and as this oral argument has suggested, it does not play a significant role in this decision, and it could very well be pretermitted depending on how this court rules on the other substantive issues. But I would like to indicate very briefly, as I did in my brief, that there are 2 reasons why the bifurcation statute does not violate the separation of powers. First, the Supreme Court has said that even if it is a procedural type statute, if it is driven chiefly by public policy and is incorporated in a legislative statutory scheme, then the court will generally defer to the legislature on that one matter. Second, this statute actually comports with and supplements the Tennessee Supreme Court decision in Hodges versus SC Toff Incorporated. I only have 35 seconds. Just jumping to how it does supplement. It actually...
Your time's expired, but we'll give you a little bit more. You can have some more. I think the clock is counting up now.
I apologize, Your Honor. I do not want to take anyone else's time.
No,
I'm happy to answer any
gonna take
questions you may have.
You had enough time to basically tell us your name, and
Yeah.
you didn't have very much, but we've got your brief, so.
Yes. But once you finish the thought you were doing, we won't take any time away from
Okay,
anybody.
I will just jump to that second argument because the Tennessee Civil Justice Act is very clear, but so is Hodges. Not only does this statute actually essentially codify the requirements, but the plaintiff argued that in non-jury trials it should have a different procedure. But the Supreme Court in Culbreth already has disagreed with that and said that the procedure should be the same in jury and non-jury cases. Further, the plaintiffs argue that discretion is all messed up because of the statute, because it's mandatory. If that statute is mandatory, it's not touching the trial court's discretion. It's not changing it, because under Hodges, the trial court had no discretion either. If the defendant sought bifurcation, then the trial court had to give that bifurcation. Thus, the statute only supplements the Supreme Court's decision that in punitive damages case, a trial court must review the elements and consider it. Thank you, Your Honor.
Thank you. Hear from the appellant in rebuttal now.
Thank you, Your Honor. I'd like to first address a comment made by Mr. Mitchell regarding the pretrial stipulations. There were stipulations in this case that did streamline the trial, principally addressing the issue of whether or not this was a public or a private concern for the purposes of standards in a defamation case. There is nothing that I'm aware of, and that we are aware of, that says anything that the plaintiff's burden of proving reputational harm was abrogated in any way. And I'd also like to talk about what the trial court found, and I think that the trial court, it's important to note, I believe, that the trial court misapplied or did not follow the correct standard principally when assigning punitive damages, but I think also in general in her view of how of Ms. Plese's basically mens rea, what she believed when she posted this, because that's what's important in this case. And I'll read from what the trial court said. Sorry. Ms. Plese admitted in her deposition that she knew that Ms. Austin was upset by the disclosure of her criminal charges to the HOA board. Her further publication of the statement was intended to paint plaintiff Linda Austin in a false light. That is understandably evidence of intent, of potentially even maliciousness in terms of why Ms. Plese posted further content. It is not, as is required by the false light and defamation, the elements of false light and defamation and the case law supported, it is not evidence that is not alone sufficient to support that Ms. Plese knew the allegation was false. It was true. You can't turn a true thing into false light or defamation because of your intent. And that's an important distinction that I think we've raised in our brief a couple of different times, and that is it's not so much as it's not being mean. Being mean is not actionable under defamation. I can reprint in any form of posting that I want to that my neighbor was committed of axe murder. I can mean to harm that person. But if it's true that the person was convicted of murdering someone with an axe, then there is no action against me, regardless of my intent. And I think the trial court does that several times throughout her opinion, and I think it's understandable because the general principle in civil cases is, in terms of maliciousness and holding on punitive damages in particular, is one of what that person meant to do, or the intent behind what that person did, as opposed to whether or not that person knew what they were posting was incorrect or to what degree. And speaking of to what degree, I'd also note that
Are you saying that the trial court's determination that malicious and reckless, it wasn't relevant to the punitive damages award?
Yes, in one sense, yes, Your Honor. It's how it was applied. I think that in cases of defamation, only the most egregious of cases are deserving of punitive damages, and in cases where punitive damages have been found, they've been instances where the person, like in Moore, knew what they were posting was wrong. They knew it was false. They knew it was false when they posted it. They knew the defendant in Moore knew that he was posting salacious things about another person, including drug use and misappropriating public funds. He knew it was wrong. Knew it was wrong when he posted it. In this case, I think even the trial court had a hard time finding that, especially when she stated, and this goes, I think, generally to what. Generally, in terms of whether or not this was Ms. Plese's conduct rose to the level of false light or her intent in general, is that Ms. Plese admitted that she was not a lawyer and not capable of understanding the nuance of a criminal statute, and she made no effort to confirm the truthfulness of her statement. She did, however, know from her background report that Ms. Austin pled to a misdemeanor charge and not a felony. So effectively, what the trial court stated in its facts and in general was Ms. Plese ran a background check on someone, took that step, found deadly conduct as a conviction. True thing. Then she took an additional step to go and look at the statute and say, hey, what does that mean? So she's got a true statement that she's relying on. She goes to investigate it further. She is a layperson that is looking at a Texas criminal statute and making a misinterpretation of that. And she makes part of that statement, part of one of her statements, based on that misinterpretation. And I think that not capable.
Counsel,
Yeah.
your time.
Sorry, my time is run. I'm sorry, Your Honor.
That's
Thank
fine.
you.
All right. We thank all counsel on this for your briefs and your argument today.
Thank you, Your Honor.